First of all, I would like to thank you for your feedback. For the Ministry of the Interior, we are most concerned about the children's rights. If the existing laws and regulations have reflected the provisions of the CRC, of course, we can go ahead and sign and ratify these covenants. However, after a few efforts to amend existing laws, our effort is right now focused on implementing these provisions. Of course, we know that if we can ratify these core human rights covenants or conventions, we will be able to improve Taiwan's reputation. Yes, we will put that as a midterm goal. But before that, we would like to substantiate the existing laws and regulations in this regard. So this is my response to your question.
Maybe you'd like to answer some of the issues raised by Mr. van Boven as well.
I'm from MOJ. And MOJ is the staff unit to the Presidential Advisory Committee on Human Rights. We are only a staff unit, but of course we want to realize the ideal, but there are some frustrations along the road, and there are so many other core human rights treaties, and President Ma attaches great importance to the incorporation of these international treaties into domestic law. And we have done some planning. In the LOI, we've replied by saying that Taiwan has conclusion of Treaties Act and Provision Act governing the incorporation of multilateral conventions into domestic laws. We're not using this as an excuse as to why we do not sign other international human rights instruments. We are simply explaining the current reality in Taiwan, since Taiwan is not the UN member. So using Implementation Act is one way out, but it is not very economical to design an Implementation Act for each and every of these international treaties. And that's why we have the provisional acts governing the incorporation of multilateral conventions into domestic laws. And we have a task force which is reviewing the possibilities of signing the other human rights instruments. Whereas MOJ has some planning. When we advised the presidential office to establish an advisory committee, we had a proposal, but the proposal did not pass. So now currently it is the MOJ which is helping to facilitate the passage of these international human rights treaties. And the advisory committee under the presidential office is in charge of coming up with the list of the conventions that the government wishes to sign. That's my response. I have something to add too. In the past, there are 3 ways for ROC to incorporate international treaties. First of all, we copy the provisions of the international conventions. For example, the Maritime Convention. We transfer the provisions in the international treaties into domestic laws. And the second way is to incorporate the provisions of some international conventions into relevant domestic laws. For example, our domestic laws on labor, or the Protection of Children and Youth Welfare and Rights Act in Taiwan also took some provisions from CRC already. The third way is to have an implementation act. There are some scholars in Taiwan criticizing the approach of implementation act, but President Ma wishes effective and efficient incorporation of international instruments. That's why, as another delegate mentions, that the draft of the provisional act governing the incorporation of multilateral conventions into domestic laws is probably a good way, because it is easy for the president to ratify, but the instrument of the ratification cannot be deposited. We cannot go through the formal international procedures. So without fulfilling the procedure, will the convention still be as effective as they should be? This might be a problem. So maybe currently that's the reality in Taiwan. So the provisional act that I mentioned should reach some conclusion or results in 6 months. The Ministry of Justice reported to the new cabinet that we are planning to move this provisional act forward. And we have solicited opinions from experts and local scholars to do some more research.
Mr. Chairman and distinguished members of the review committee, as our head delegation already stated this issue very clearly, but from the policy of the Ministry of Foreign Affairs is to strengthen Taiwan's international legal network or relations with the international community. This is our major policy of this Ministry of Foreign Affairs. Even though ROC Taiwan was not a member of the United Nations in 1971, but Taiwan, we are still very active to develop its international relations. And then for the purpose of the safeguarding the human rights of its nationals, okay, so our government produced a national human rights report, and this action, they show the determination of the government to the world. And these actions and these reports is in compliance with the 2 covenants and other UN core instruments of human rights. So this Ministry of Foreign Affairs will try its best to coordinate with the other concerned ministries to ratify the other UN core instruments. But it's an internal coordination government network in a long-term future. But as you know, Taiwan is not a member of the United Nations. So the following problem arising, the lacking of ratification or assessment instrument failing to deposit to the United Nations Secretariat. So we have a very heated discussion in Taiwan, and we also call upon international lawyers and experts to discuss these issues. And these ministries already draft a law on treaty making to deal with the issues of the deposit problems to the United Nations. As long as our government decide to ratify the other core instruments of human rights. Then, according to the legal purpose of that draft, it will translate those international treaties or conventions into our domestic laws. But the whole draft now was sent to the legislatures for approval. But now our government already decided it's a top priority draft to complete. This is my brief comment.
Well, thank you very much. But I would like to come back to what the Deputy Minister of Justice has said, and that is that there are basically three modalities of transformation, not ratification, transformation international law. One, to take everything on board and transform it into national Taiwanese law. Secondly, take issues and look at various laws and see how these various laws, labor law and family law, etc., need to be changed, and put the changes in there. And many government departments like that, because then they are only responsible for their own department and can deal with that. The danger is, if you do that, that important issues are left out. So it's much better to have the whole thing. And the third one, if I understood you correct, is the Provisional Act. So either the first or the third option, I think that's the one that I found most convincing from what you have said. The ratification issue, I do understand, and we all understand, that the windfall profits for your country, if you fully comply at the internal level with international human rights norm, that will enhance your visibility and your being best practice for many other countries that have the same problems. Okay, yes, Philip, and then I give back to you.
Thank you. Just one brief point on the Convention on the Rights of the Child. I think that it's very important to recognize that the text of the convention, has changed fairly dramatically the law relating to children in most countries in the world. It is not, in my view, and I was heavily involved in the drafting of that convention as the advisor to UNICEF, it is not, in my view, possible to capture the real essence of the convention by simply taking selected aspects relating to the well-being of children. The key dimensions of that convention relate particularly to what are termed the evolving capacities of the child. In other words, recognizing the child as a holder of rights, himself or herself. I think it's significant that in all of the documentation we have before us, there is very little relating to children, other than in terms of their welfare. But even in terms of juvenile justice, there is remarkably little. This is all the more surprising given the prominence of the Convention on the Rights of the Child, which, as you know, has been ratified by every one of your neighbours. And I think to move ahead on that convention would provide a very important segue, if you like, for Taiwan into a lot of the activities of the international community, which clearly is one of the objectives of this whole exercise. Thank you.
Thank you very much. Would you like to briefly respond? Thank you.
Thank you very much. Thank you all for your opinions. I would also like to add something. And the domestic protection of children, we have more than the Protection of Children and Youth Welfare and Rights Act. There are other laws and regulations. For example, in our Sexual Assault Prevention Act, in our Domestic Violence Prevention Act, and Family Education Law, and Gender Equity Education Act, there are all provisions regarding the protection of children. The Children and Youth Welfare and Rights Act is the primary act, while there are other laws and regulations that have provisions for that protection. This is what I want to raise. And as you mentioned, that as you suggest, we should try to sign and ratify CRC. I think the Ministry of Interior will continue to discuss with relevant government agencies and to find a way, to find a good time, to find a good approach to sign and ratify CRC. We will do more research and welcome more discussions. I also have something to add. Among the three modalities, well, as for the second modality, it's true that some experts say that it is not the best practice. As the government has reviewed, there are 263 cases that there are inconsistencies between domestic laws and international covenants. And it is possible that the agencies only pick and choose the provisions that they deem suitable and incorporate them into domestic laws. So in the future, we should prevent that approach. In the future, in the future, I think approach the first and the third modality will be used more in the future. But when we do all that, we need to consider the reality in Taiwan. And we also need to consider whether there is an issue of reservations of international instruments.
Yes, thank you very much. But I think I would like to cut this part of our discussion short because we have some very big issues still pending. We can come back to it, of course. And what Mr. Alston had said in relation to CRC, that you have to see it as the whole concept of the evolving capacities of the child. The same goes for CRPD, for the Disabled Convention, but I think we will deal with that under specific articles of the Covenant. We don't have to do that in the core document part, but we'll come back to that. But it's the same issue, whether a reasonable accommodation or borderline problems or empowerment and barrier freedom and things like that. They cannot be done just by slightly changing a provision in a statute. Okay. I will now, I have a number of speakers, but first of all, I go back to Theodoor van Boven because his fourth point was corporate responsibility and the fifth, transitional justice. I think we have time to do both, but perhaps try and be relatively brief on the first one. Okay.
Well, just to finish this point which we have been discussing, I very much agree with the representative of the Ministry of Foreign Affairs that Taiwan accepting the obligations under these conventions will strengthen also the international standing of Taiwan. I think that is an important element we should keep in mind. But it is not only the question of international standing, but what is needed domestically. And in fact, there was strong social pressure to accept the obligations under the CEDAW Convention. But there are other groups who have not such a strong voice in your society. The disabled persons, some migrant workers, they are on the margin, they are vulnerable persons. And I think their voices that are very not so strong, but should still be heeded. And now coming, I had in mind also the Implementation Act relating to the international. We will skip that because I think that has been already touched upon in the previous discussion. So I come now to the corporate responsibility. This is in fact an issue which was not included in the core document, but we raised it in view of a statement adopted by the Committee on Economic, Social and Cultural Rights in May 2011, when it called on states, and I quote, to include in their initial and periodic reports challenges faced and measures taken in relation to the role and the impact of the corporate sector on the realization of economic, social and cultural rights, end of quotation. The committee mentioned as examples of corporate activities detrimental to the enjoyment of these rights such matters as unsafe labor conditions, restrictions on trade union rights, discrimination against female workers and migrant workers, and corruptive practices. I'm already grateful for the reply of the government commenting on these matters and for drawing our attention to the corporate social responsibilities best practice principles. Now, the issue of corporate responsibility is also expressly and explicitly raised in a recent briefing paper by the International Federation for Human Rights based in Paris and the Taiwan Association for Human Rights. In a section on land rights and environmental rights, it's stated that, and I quote, some Taiwanese corporations have built their competitiveness on poor labor conditions, lack of effective legal constraints or reputational pressure to observe human rights, and operations in countries where human rights standards are poor. Thus, Taiwanese multinationals have been involved in a long-standing land conflict in Co Công province in Cambodia over an economic land concession that resulted in widespread displacement, livelihood impacts, and other human rights violations. The two human rights organizations just mentioned are recommending binding legislation, holding corporations accountable in case of violations of their responsibility to respect human rights, and regulating extraterritorial activities of Taiwanese companies operating abroad, and such imposing respect for human rights in all circumstances. So it is a rather recent and new subject, but I think it is important that we discuss it and bring it to your attention. Thank you.
Thank you very much. Would you like to respond immediately? Yeah? Yeah? Okay. By the way, if at any stage you would like to reflect and discuss it amongst yourselves before answering, then we will just continue the questions. You just signify it to me, and then you can come back a little later. So you don't have to on the spot, because sometimes it's the esprit d'escalier that's important. You have the floor.
I'm from the Council of Labor Affairs. Yes, we understand that the corporate sector needs to take care of their laborers, which is also an indicator of human rights protection. In fact, we have enacted some regulations to look into that. For example, we have Labor Standards Act, which is a minimum standard that all labor employing enterprises will have to comply with. In the event of violation of the Labor Standards Act, punishment will be meted out accordingly. Also, we have been promoting this knowledge, organizing outreach programs to the corporate sector. In these workshops, we invited representatives from different competent authorities to talk to the corporate sector so that the employers would know better how human rights can be protected in the workplace. That's all. Thank you.
Thank you very much. Anybody else from the delegation? You?
Yes. In terms of the union rights, we have the union right, the Labor Union Act, and another 2 regulations which have to be honored by all employers on this island. When it comes to corporate social responsibility or the responsibility on the corporate sector, the government has been paying close attention to ensure that the corporate sector understands its obligations. In the past, the welfare of laborers may have been compromised, but now this has been improved. For example, the MOJ is also promoting government transparency initiative, which also looks into corruption between the corporate sector and the government sector. Very often, labor's interest may be compromised because of such corruption. That's why, under the MOJ, we stepped up our efforts to crack down on corruption, but that also means we will work more closely with the corporate sector. In addition, there will be more detailed investigation into different sectors.
Thank you very much for those additional remarks. And I would highlight what Theo van Boven has said, that the Committee on Economic and Social and Cultural Rights, when dealing with the Ruggie reports, and we had meetings with his team and things, the committee said there is much too little talk on the human rights dimension. There is much too much talk about policy choices in the intergovernmental processes that the Human Rights Council primarily addresses. And so therefore it was very important. And just one word on the statements. You have the general comments, but increasingly the statements are preparatory to a future general comment and are usually very brief, very short, and pick up in the general political debate and say what the committee from a strictly human rights perspective has to say for that. So you should also have on the homepage of the Office of the High Commission, there are now 20 such statements, some of them on the right to development, on corporate responsibility, on the macro questions are really helpful. You might find them useful in your own practice. But thanks for what you said. I would like to say, structuring the debate as it goes on, are there further members of the committee to wish to speak on the issue of corporate responsibility? Okay, I have 2 speakers on that side. Okay, and then we go over to transitional justice, and then the issue of independence of judges that some committee members would wish to raise. So just for you to know, we have quite a long list, but we have time. So who would like to start? You, perhaps, Asma?
Thank you, Mr. Chair. I want to comment a little bit on the responses given on this topic. We heard about the laws existing in the country to protect labor rights of workers, and we also heard about the law that protects the right to form unions and represent the voices of the workers. However, in terms of corporate responsibility, this is not enough because there are other rights, positive duties to reach out to, for example, the disabled community, whether corporations are going out of their way to ensure the employment and the kinds of facilities that would be needed for disabled persons, whether there is not just violating the labor rights, prevention of the violation of labor rights, but having positive duties to facilitate employment for certain groups of people that may be marginalized. And that is not in your labor law, from what I've heard. And this is something to consider. Secondly, what I did not hear was a response to the need for legislation that would bind corporations, preventing them from, giving extraterritorial jurisdiction where Taiwanese companies are operating in other countries, to prevent them from violating rights in those countries. We didn't hear a response on that. So could you please respond to that possibility of having legislation which would then regulate extraterritorially the actions of corporations?
Well, in terms of the people with disabilities and their employment, we do have an act on the protection of the rights and welfare of persons with disabilities. And some provisions are related to the employment facilitation by the corporate sector. For example, a percentage of the payroll has to be persons with disabilities. Moreover, in order to help this corporate sector to hire more disabled employees, we have measures to help them. For example, we do have a task force to help those employers to redesign their work procedure so that they can accommodate employees with disabilities in their factories. In addition, we would also aim to, we just finished amending a law allowing the corporate sector to employ persons with disabilities in their subsidiaries or spin-off so that they can meet the requirement in these provisions. Good afternoon. I speak on behalf of the Ministry of Economic Affairs. I would like to talk about the efforts we have made in this area. The MOEA has been engaged in OECD-related activities for years, so we have been following closely the guidelines for the operations of multinational corporations. Therefore, we have translated that guidelines into Mandarin Chinese so that the local enterprises can reference these guidelines. We also have outreach programs and workshops to promote the idea of corporate governance, encouraging companies to comply with international human rights standards at home or abroad. Right now, it's mainly promotional and educational in nature. And in the year 2000, we implemented a new statute governing the upgrade of industrial sectors. One of the provisions says that we could encourage the corporate sector to strengthen their corporate social responsibility by implementing green manufacturing practices in their factories. Our small and medium-sized enterprises administration also provides a lot of loans, preferential loans, to encourage SMEs to contribute, to give back to local communities where they are based. these are some policies we have in place to encourage SCR. In fact, we also emphasize the importance of strengthening corporate governance in one of the initiatives proposed by the MOJ. We organized workshops and seminars to communicate with the management of multinational corporations in Taiwan. Moreover, according to the anti-corruption law, there are also clear provisions concerning corruption conducted by either government officials or the corporate management executives. So we are taking steps to improve the situation.
Thank you very much. I think Nisuke Ando had a question from this. You come later. Anybody else on this issue? In that case, I come back to Theo on issue number 5, transitional justice. The floor is yours. Thanks for being so patient.
Well, it is not a question of patience, but I think it often very interesting and helpful discussion. On transitional justice, Mr. Chairman, there is not much of it in the core document. Only it is mentioned that in 1987 martial law was lifted and that Taiwan embarked on a journey towards becoming a truly pluralistic society. That is stated somewhere in the beginning of the document. In fact, what happened in these years of during the martial law, years also referred to as the years of white terror, and I think also the President yesterday night in its encouraging, inspirational speech referred to that. We can just not overlook what has happened, in particular in relation to those who have been suffering as political victims and prisoners. And in fact, Taiwan is not the only one to have experienced such a dark period. There are many nations, in fact, that went through these years of repression, years of terror. And in fact, many nations have tried to come to grips with that, some with better efforts than others, in particularly in setting up truth and reconciliation commissions. Now, this issue has also been brought to our attention by a number of non-governmental organizations, and rightly so. Now, it seems, if I'm well informed, that Taiwan has given some compensation to victims in terms of money. Well, money is not repairing everything, and I think also there is a need also for rehabilitation of persons and for people and for the society in order to know the truth, what really happened. And I think, therefore, more is needed now to deal with that issue. It is also along the lines of the United Nations principles and guidelines to a right and remedy for victims of gross violations of human rights, as well as measures to open up the truth about what happened in those dark years. So this is an important issue which should not be overlooked, and it should be taken up also as a matter of truth and justice. I think that is in the interest of the whole society of Taiwan. So I thought it is important to raise this issue also, although it is not included in the core document. Thank you.
Would you like to respond?
Thank you very much, Professor Van Boven. In terms of political cases, well, there are two acts in Taiwan that are related to this regard. There's a Compensation Act for 228 incidents, and there's another act for improper trials to compensate victims in the White Terror era. There are two foundations that are in charge of reviewing and providing compensation to the victims. And as for the reinstating of one's reputation, our 228 Incidents Foundation deals with that too. On February 28th every year, we organize a memorial event. We provide a ceremony for past victims to reinstate their reputation. There's also some funding from the Ministry of Interior to fund the 228 Incident Foundation to keep researching on the fact of the 228 incidents. From time to time, we organize exhibitions too, so that both the government and the private sector will continue to remember the incident and bear that in mind so that we can move forward to pursue better realization of human rights. Speaking of martial law periods or White Terror, in addition to the previous delegates' opinion, the Ministry of National Defense also has similar policies. You're all welcome to come to our Human Rights Park, which was relatively new. This shows that we want to remind people of what had happened in the past. And speaking of transitional justice, if it is a violation of human rights that is related to criminal act, the MOJ now want to promote restorative justice so that perpetrators and the victims can have a dialogue through a third party to forget about the past and to move on to their respective future. This is our new policy, and we also have a new act to protect the victims. Maybe the details can be supplemented by another delegates from MOJ. Mr. Chairperson, dear committee members, the MOJ started to promote restorative justice from 2 years ago with the aim to create an opportunity for perpetrators and victims to sit down and communicate with each other. Through such a procedure, we hope that the perpetrator will learn how much harm he or she has caused on another human beings or people, and to learn about how to reintegrate themselves back to the society. So far, this procedure has generated quite a few positive results, and we can supplement you with extra information maybe later or on the other day on restorative justice.
On similar issues in relating to housing rights and compensation and rehabilitation and restitutio ad integrum, we can deal when we deal with Article 11. So. Of the social covenant. Yes, but this said, I now turn to, does anyone from the committee wish to comment on what was just said by the government delegation on this issue? Yes, please.
It's been a fascinating exercise for me to watch the last hour and 40 minutes and to see the progress that's underway and the stimulus that our visit seems to be giving to your commendable efforts. I have some questions about the most effective form of implementing some of these reforms, especially in the context of transnational justice. Is it your view that a commission is necessary? In addition to what we've just heard is underway, is it your view that such a commission should be established under government auspices with all the difficulties that were pointed out earlier that accompany the establishment of any kind of commission because of your unique separation of powers, because of the multiple agencies involved in any kind of human rights? Do you oppose the establishment of a government commission on transitional justice? Do you favor a non-governmental organization? Is there a role for the control yuan here? Can one have confidence in the control yuan because of the extent to which it's governed by political considerations, including its relation to the president's office and other agencies? It would be good to hear a little more about the institutional questions. This comes up in other human rights contexts where whenever it's suggested there ought to be an independent commission to investigate this or that, often the answer is, we don't need it, we have the control yuan. And is that a sufficient answer? So it would be interesting. Let's talk about this specific question of truth and reconciliation. Is there any institutional need that's not being attended to, or is this the best of all possible worlds?
Thanks very much, and I'll give the floor back to you.
刚刚委员指教的，是不是要由政府再来成立一个所谓的一个真相调查一个这样的机构的话，事实上，我想我刚刚已经做了说明，我们在228事件的部分，我们有定了一个专门的法律，然后在戒严时期不当政治审判的部分也有定。
And we have two acts. One is for the 228 incident, and another act specifically for the mistrial or non-proper trial in the white terror area. So there are two dedicated acts. In addition, we have two foundations, and the foundation members are from different political parties. They are from the civil society as well, and the foundations look for the truth of the incidents and then facilitate the provision of compensation or to help these victims to reinstate their reputation. And on February 28th, there's a ceremony every year when the president will give the certificates to the victims to reinstate his or her reputation. And the government has been doing that for the past 20 years. So in the current framework, we think this mechanism works, and therefore there aren't suggestions as to whether we should or to establish such a Truth and Reconciliation Commission in the government.
Just a quick follow-up.
I think earlier, where this discussion is concerned, I think the chair pointed out that there are many approaches to transitional justice, not just compensation and money. You do have improper trial and restoration of reputation. That is another approach to transitional justice. But I think a third one, which is very, very critical for closure, is for people to be able to come and say, this happened to me, I suffered. And we need a mechanism for that. And also, in line with that, to be able to name the perpetrator. You know, perpetrators have to be named. We are not even talking about prosecution or penalties or anything, but to name these were the perpetrators and I suffered and these are the people who suffered. And I think that is very critical that you look into that. You have said that you think, the last speaker said, you think that what you are doing right now through the Compensation Act or the Improper Trials Act is sufficient. And my question to you would be, how do you know it is sufficient? Have you done any kind of surveys or tell people to report and say, we are happy with what you are doing, or we want more, or we want more? Very often I hear this at reviews like this, the government says, what we are doing is sufficient, but they never tell us how they know that it is sufficient.
Would anyone wish to comment on the comment?
这个部分我在做。
Allow me to explain. The 228 incident in Taiwan is a single and unique incident, while the Improper Trial Act covers more cases because it is not for a particular case. And you ask about how we know the two acts are sufficient. Now, we continue to collect suggestions and opinions regarding these two acts. So far, we have not seen any opinion saying these two acts are not enough, but we will continue to review these two acts. And well, compensation, reinstitution, of his or her reputation, and for the victims to say that this has happened to them. Well, we have all that in Taiwan. In addition, we have a 228 incident memorial hall. There are regular exhibitions in this hall, so that people now can go to this memorial hall to gain a deeper understanding of the 228 incident. And a national research institute continues to do research on this historical event as well. And thank you very much for your opinions. The government will stay modest and will continue to contribute more effort.
Thank you very much. I now turn to Mrs. Asma Jahangir, because she has some issues relating to the independence of judges.
Well, let me just, I have few questions very much focused. So I will say them all and then seek your responses. I know that you have made important advances, but as your own government said, that much more needs to be done to guarantee all human rights to everybody's satisfaction. And it's not just political will. We can see that the political will is there just by the fact that 10 of us are here, but it also means building capacity and to be able to identify those nerve centers where you begin your work and you get more dividends. And above all, I think that what is now coming out and which is more and more obvious is that you need a governance that is human rights friendly. You know, what does good governance mean? Good governance doesn't simply mean catching people, teaching people a lesson, but good governance means that it's got to be human rights friendly governance. And to reach that, since you have a law which implements the two covenants, has there been enough training amongst bureaucrats on what these two covenants say? I know that you have research department, but do you also have monitoring and advocacy? Because I didn't see that monitoring and advocacy was being done by government, yes, research. Because often monitoring and advocacy is left to NGOs to do. For example, monitoring and advocacy on how many torture cases took place, when they were reported, was impunity given to the perpetrators, or were perpetrators actually brought to justice or not? what are the prison conditions, what is being done about it, advocacy in terms of making it possible for the citizens to come and approach different agencies of what is happening to them. This is my first question. My second question is about election reforms. The election reforms, have they been done extensively enough to allow all political parties to join into the race, or are there certain impediments in terms of, as we heard this morning, of security, high security monetary deposits and other such things which keep some people out? So is there open access to political participation by all groups or not? That's my second question. My third question is, and this is what I call the nerve center, is about media monopoly. How is the, because we heard that there is a media monopoly that is developing, do you have an oversight, a complaints commission? It can be free media, and I think we all stand for a free media, but also a responsible media. And monopolization of the media is one way of undermining freedom of media. My last question is on judiciary, because I saw in your constitution that the members of the superior judiciary do not retire, they're there till all their life. And we also heard this morning, and we have some other reports as well, suggesting very much that the judiciary is quite politicized and lacks all the ingredients of an independent judiciary. So how are they appointed? What is the selection process? This, I think, and is it a diverse judiciary? When I say diverse, I mean, do people come from different backgrounds? Or is it very much judges and judges' extensive families that are all inducted, who all have the same kind of mindset into the judiciary? Does it have a diverse mindset, or does it have a single mindset, either of an elite or of an extensive family, or of a particular group of people? Now, that is my question. These are my questions. Thank you.
Well, thank you. And there are quite a bunch. So I propose that we go one by one. Deal with the first one first. Governance that is human rights friendly, training amongst civil servants, and impunity and prison conditions. That's the first question. Who would like to speak on behalf of the delegation? Mr. Minister.